Welcome to Tech in the Courts, the series that Washington Legal Foundation and TechFreedom have been putting on. This is the fourth program in our series. My name is Glenn Lammy. I am the Executive Director and Vice President of the Legal Studies Division here at the Foundation. For those of you not familiar with the Foundation, we're in our 47th year of free enterprise-oriented advocacy and education. We do our work through a number of different means, through amicus briefs, filing regulatory comments, publishing on a wide range of issues, putting on programs such as this one, and having a blog as well. TechFreedom is a nonprofit, nonpartisan technology think tank launched in 2011. The organization seeks to advance public policy that makes experimentation, entrepreneurship, and investment possible, and thus unleashes the ultimate resource, human ingenuity. Although the concept may seem counterintuitive to some people, it's not uncommon for an American business to openly ask federal regulators to, well, regulate. While some businesses might seek more or different oversight as a competitive tool against less well-capitalized companies, most make these requests because they prefer one set of rules over 50, or they just want clear standards. Our discussion today examines this dynamic as it is playing out in the crypto industry. A company is pleading for clear standards and due process protections, but a stubborn agency continues to jam a square peg into a round hole. I'm pleased to introduce one half of our conversation today. Corbin Barthold is the Internet Policy Counsel and Director of Appellate Litigation at TechFreedom. He writes on tech legal and regulatory and social issues for a wide range of outlets, including City Journal, The Bulwark, Reason, Lawfare, Tech Dirt, and The Daily Beast. Corbin also hosts the Tech Policy Podcast, which this is going to be available on after the program, and he previously served as Senior Litigation Counsel here at Washington Legal Foundation. Corbin, if I can hand it over to you.
Thank you, Glenn. Again, I'm Corbin Barthold, Internet Policy Counsel at TechFreedom. I'm delighted to be here for another installment of the Washington Legal Foundation TechFreedom Tech in the Courts series. Once again, I'm also here as host of the Tech Policy Podcast. My warmest welcome to our listeners there. Come in and register. That was the refrain the crypto exchanges kept hearing from SEC Chairman Gary Gensler, but it was empty talk. The SEC has persistently refused to supply the crypto industry with much needed guidance on how exchanges could possibly comply with the securities laws. The agency has even had the audacity to claim that it can't issue rules because it's too busy with other priorities. Never mind that it has had the time and energy to sue the major crypto platforms in federal court, alleging securities violations. A federal judge recently called out this cynical campaign of regulation by enforcement. It looks like you're going after the platforms, he said, in a way that will crush the industry without getting into rulemaking. Government hostility toward crypto stretches beyond the SEC. Several agencies appear to have engaged in a coordinated effort, sometimes called Operation Choke Point 2.0 by its critics, to shut the crypto industry out of the traditional financial system. But there are also bright spots. The CFTC has been open to setting up reasonable crypto regulation, and the House recently passed a crypto bill that received a generally favorable response from the industry. There are so many interesting regulatory issues surrounding the crypto industry. Fortunately, I'm joined today by the perfect person to help us make sense of them. Indeed, this man is at the center of the action. I say these are interesting issues. He could be forgiven for calling some of them infuriating. Paul Grewal is Chief Legal Officer of Coinbase, the largest cryptocurrency exchange in the United States. Also a former federal magistrate judge, which is very cool. Coinbase has led the effort to get regulatory clarity from the SEC. It is now suing the SEC. It is also being sued by the SEC. And it's supporting a FOIA action against the FDIC, digging into Operation Choke Point 2.0. Paul is a busy man, and I'm grateful he's taken the time to join us and talk about as much of this stuff as we have time to get into. Paul, hello, sir.
Hello, Corbin. Thank you for having me.
So good to have you on. Personally, I am a legal nerd. I would love to just dive into all the administrative law stuff I kind of laid out there, but I don't think we can take for granted that this is a pro crypto audience. This is not the Bankless podcast. So first, I think we need to start with why crypto. Imagine that I am the late great Charlie Munger, notorious crypto skeptic, and give me, the vision for crypto. I've heard your CEO, Brian Armstrong, spend about 15 minutes on this. I'm afraid I'm going to ask you for more of the elevator pitch, but there's your first task. Go.
Happy to do it, Corbin. And as a fan of so much of what TechFreedom and the Washington Legal Foundation have done over the last several years, it really is an honor to be here with you. Look, 52 million Americans at this point, Corbin, have owned a cryptocurrency or digital asset. And so it is remarkable to me that in 2024, we are still having this debate about why crypto or what rules make sense for crypto. And yet, if you can do the basic math, that means that well over 300 million Americans either are ambivalent towards the topic or maybe even skeptical or even hostile. And that's okay. I think, it's important for us to have a conversation like this one so that everyone can reach their own conclusions. And at the same time, understand that whether you like crypto, hate crypto, or don't really care about crypto, sensible rules just make good common sense. What crypto offers, I think it's fair to say in a nutshell, is a new paradigm for money, for a financial system, and for freedom that ultimately we think will benefit not just 52 million Americans, but hundreds of millions of Americans over time, and hopefully billions of people all over the world. And the basic promise of crypto is this. In the traditional financial system, you often find that individuals are forced to interact with their resources, their money, through intermediaries. This is the bank down the street, or the large financial institution in New York or around the world, that effectively sits between people, regular people just looking to do regular people things, and their money and their resources. And that dependency upon centralized actors is what I think distinguishes the traditional financial system from a system that is decentralized, that doesn't require trust and confidence that these actors will do the right thing at all times. And that's really where crypto comes in. It's the opportunity to rely upon an alternative mechanism or network for consensus around who owns what and who has a claim on what assets. And I think it's that appeal, it's that possibility that has captured the attention and even the imagination of so many people all over the world.
Great. Okay, so now we can get into the lawyer stuff. You guys, Coinbase, you want regulation.
We do.
And we should be clear about that up front. But the current scheme, I think you could describe it as a horrific lack of fit between the current securities regulations and crypto exchanges. And the SEC has gone back and forth about whether most cryptocurrencies are securities, but they finally landed on most of them are not. And they came and they sued you guys, and that is ongoing. Other podcasts may want a high overview here. They want the elevator pitch of this issue. This podcast now, if you ever wanted to get as deep in the weeds as you wanted to,
love it,
on the lack of fit between the securities laws, the disclosure requirements, the custody rules, the licensing rules. Now's the time. I want to completely geek out on why these rules, which have the origination in the New Deal, the 1930s, don't make sense for your company.
Let's do it. So look, as you suggested, Corbin, Coinbase as a company, me personally, not only welcome regulation and rules, we're begging for it. In fact, Corbin, I'm suing the SEC in order to get rules, which puts us in a little bit a different place than I think the caricature of so many in industry as trying to evade or escape oversight by the government. We want it. And we want it because ultimately, for crypto to reach its full potential, for it to be adopted not just by the technology leaning and bleeding edge part of the market, for hundreds of millions or indeed billions of people to embrace it, there needs to be trust. There needs to be confidence that people can interact with this new technology and this new asset class in a way that they can count on. And so we've always believed at Coinbase that regulation is the key to that. It's one of the reasons why we've operated here in the United States in plain sight for over a decade. We are currently licensed and registered in the state of New York by the New York Department of Financial Services. We have oversight as a money services business at the Department of Treasury, and we have money transmission licenses in 45 or 46 states, depending on how you count, all across the United States that offer those types of licenses. To say nothing of our licensure and registration all over the world. So we are a company that believes in regulation and oversight. And yet, when it comes to one particular agency, the Securities and Exchange Commission, even though we've had broker-dealer registrations for some time, the overall registration scheme for crypto doesn't work. Corbin, you mentioned the fact that the laws that the SEC is charged with applying were written and enacted by Congress during the New Deal. It actually was the earliest parts of the New Deal in the 1930s, 1933 and 1934 specifically, when the SEC first came into existence and was tasked with overseeing securities markets. The laws that were written at that time defined securities very broadly, to be fair, but in particular ways that just don't make sense for crypto. Now, what do I mean by that? Well, the SEC has always latched onto one particular species, one type of securities as giving it all the authority that it believes it needs in order to oversee this market. And that's the particular security known as an investment contract. Now, I'll pause just to note the SEC's claim today that the definition or meaning of investment contract covers just about every kind of cryptocurrency or digital asset on the planet is in marked contrast. In fact, it's contradicted by the statements of the current chair of the SEC just a few years ago. Gary Gensler, who has served as the chair of the SEC now for over 3 years, testified before Congress not long after we were allowed to list as a public company in 2021 that the SEC lacked the regulatory authorities necessary to oversee cryptocurrency exchanges like Coinbase. And so as of that time, after we were allowed to list as a public company, and based on the testimony of the SEC chair himself, the SEC had a view that this investment contract term did not cover most or all of what is being traded in crypto. And yet, fast forward several years, that is the entire hook for their claim to be able to regulate this entire industry. Here's the problem.
I've always thought it was interesting, by the way, just to cut in, that the SEC is the same. They're the same people who said, "Oh, hey, you can list as a public company," and then they turned around and said, "Oh, basically everything you do is illegal."
And when you apply to list as a public company, Corbin, you know this, but your audience may not fully appreciate. This is not simply like filling out a form at the DMV and getting a driver's license after a basic test. This is an exhaustive, excruciating review that the SEC conducts over your entire enterprise, all of your disclosures, to make sure that what you're telling the public about how your business operates is in fact accurate and squares with the law. And in fact, when the SEC has to decide when you're allowed to list, when your registration statement can become effective, they are specifically charged by Congress with establishing that an accelerated or effective registration is in the public interest. And so, yes, this same commission that by law had to decide and establish that allowing Coinbase to list publicly was in the public interest, just a short while later pulled a 180 and suddenly determined, in its own mind anyway, that all of these assets that we were listing and allowing people to trade were somehow unlawful. It just doesn't square with common sense. And so that's why we have pushed so hard since then to establish both a private dialogue with the SEC, but also a public record that the SEC's interpretation of the law surrounding this investment contract term is contrary to law, contrary to the precedent set by the Supreme Court and others, and frankly, at odds with their own internal analysis and conclusions just a short while before.
So I cut you off, sorry, but I do want to hear some about, what a normal disclosure requirements look like and why do those make no sense for crypto? And why is the custody regulation incoherent for crypto, and maybe a bit about the licensing rules, because if ever there were a place to get into the weeds on why this makes no sense, I think WLF Tech Freedom, this is the stage.
Well, I feel among my people here, so let's get into it. Look, the for an exchange to come in and register, as Gary Gensler has suggested, is all that is required. Would normally be a quite reasonable position for the SEC to take. It's frankly why we have pushed so hard for rules that would allow us to do just that. But under the current rules that are in place and that apply to all manner of securities that may be transacted on an exchange, there are very specific requirements for the issuers of the so-called security to comply with the rules, and therefore the types of issuances that the exchange can list. And it won't surprise you to know that traditional issuers look very different than most typical cryptocurrency projects. A traditional issuer of a stock or a bond has a board of directors. It has a management team. There are certain financial statements that are prepared, all of which make perfect sense. In fact, as a public company, Coinbase once a quarter complies with all of those rules. We have no problem with that. But they don't make sense for projects that are often not started or maintained by traditional corporations. In fact, in most cases, they are much more loosely affiliated groups of individual software developers and programmers. They may be distributed not just across the country, but indeed all over the world. And so requirements, for example, that you list who your board of directors are, what their address is, and what their backgrounds are, don't make sense for organizations like most cryptocurrency projects that don't even have a board of directors, let alone operate in that fashion. The rules also require that the intermediaries or exchanges that operate to list these types of tokens maintain certain functional separation between the broker, the dealer, the exchange, the clearing agent, all the different elements that are part of any transaction of a cryptocurrency token. Here's the problem. Here's the problem with those requirements as they apply to a Coinbase. The fact of the matter is that crypto, indeed the whole point of crypto, breaks down those barriers and addresses so much of the inefficiency of these different actors, all intermediating a single sale or purchase of an asset or trade of an asset, and all of which want their own cut, right? Every layer in between two people or two entities wanting to trade, it's just another added cost and burden and effective tax on that transaction. What crypto is so effective at doing is eliminating the need for all of those intermediaries and being able to effectively settle trades instantly. That's the beauty of a blockchain-based network that is reliant upon public consensus or distributed consensus that a transaction is valid, as opposed to some big financial institution on Wall Street vouching for it and everyone else having to hope that stamp of approval is in fact good and that they can make good on any mistakes that they might make. So the rules are a square peg in a round hole, to borrow Glenn's earlier analogy. And what we've said all along, Corbin, is we don't resist the idea that there should be a registration and that different parties, including Coinbase and issuers, might have to come in and register under certain circumstances. But let's adapt those rules in a way that makes sense for this technology. And by the way, Corbin, asking for adjustments and adaptations, that's not asking for special treatment for crypto. We do this all the time when it comes to securities transactions. For example, mortgage-backed securities and other specialized forms of securities transactions often have adjustments to the generic standards that recognize that they operate in a certain way and that the purchasers of those instruments may need a certain type of information in order to make an informed choice. So we're just saying, let's apply the same standards, but make accommodations that frankly improve the safety and securities of these markets rather than undermine them. For some reason, this SEC, or at least this SEC chair, just refuses to engage in any of that and has adopted a much more hostile, antagonistic approach that either you follow the rules as we set them, or we're going to sue you out of existence.
Well, that segues into the next thing I wanted to ask you, because a law can be a bad fit for a company or an industry and still just be the law. That is not an illogical thing that could happen. You've been sued by the SEC for securities violations, and they are claiming that actually, if only they were so clear on which ones they think are securities and which they think are commodities. So Bitcoin, a commodity, although they backtracked in front of the Third Circuit. Let's put a pin in that. Maybe most of them securities. I mean, all they got to do is find one and you've got a problem, right? Because you can't trade both securities and commodities on the same exchange. I digress. They're pointing to what's called the Howey test under a Supreme Court case. I got to say, when you recite the case, the test, it sounds kind of like a haiku, an investment of money in a common enterprise with the expectation of profit to be derived from the efforts of others. Not a lot to go on there, actually. That could mean almost anything if you read it a certain way. Why do you guys not have the Howey test on your commodities, let's call them? Why should you win this lawsuit? I think I'm done. Go ahead.
So look, we've said all along, it may entirely be the case that there are cryptocurrency tokens and projects which ultimately are part of securities transactions and should be regulated as such. At Coinbase, what we've attempted to do, and we believe we have effectively done, is to avoid those types of tokens and focus only on the vast majority of cryptocurrency projects which do not fall within that framework, the Howey test, as you just articulated it, as the Supreme Court has laid it out, and therefore do not fall to the SEC's jurisdiction. The reasons vary from project to project, to be sure, but in its essence, Corbin, the problem with the SEC's theory is that that each of those elements are simply not satisfied. I could focus on investment of money. I could talk about the efforts of others. Let me talk just for a moment, in the interest of focusing our conversation, on the common enterprise test. You mentioned that the investment of money has to be in a common enterprise. Well, decades and decades of cases have interpreted that requirement, among all of the others, as requiring that there be some type of horizontal or vertical commonality among all of the different investors of the project, as well as the promoters or backers of the project, in a way that is more than just an alignment even of interests, but that really ties the return that a purchaser or an investor might receive to what the promoter or backer of the project is doing in order to drive value and increase value over time. And what's critically important is to understand that it's not just enough that you have a promoter or a backer doing a bunch of stuff that will drive the value of these tokens up over time, or at least even that would be the aspiration. What you have to show is that there is some contractual undertaking between the issuer and the purchaser that binds the two together, that gives the purchaser a claim on an issuer or promoter that fails to meet those obligations or honor those commitments. That's been the case law for decades, and yet for some reason the Securities and Exchange Commission would have you and I and all the others interested in this space believe that it's simply enough for there to be tokens on the one hand and efforts on the part of the promoter on the other. And here's why their logic is so flawed, Corbin. If that broad view were enough, then it would absolutely be the case that all kinds of collectibles would qualify as securities. This is the famous Beanie Babies example that many of us point to. It simply can't be the case that when I buy a Beanie Baby and the manufacturer of the Beanie Baby makes a bunch of promises about what they're going to do to create excitement around them, that if I'm not satisfied with their efforts, I can sue them under the federal securities laws. I might be able to sue them under all sorts of other areas of the law, and that's perfectly fine. But there's no contractual undertaking or binding obligation or post-sale obligation that I could point to that says you entered into some kind of contract with me or some kind of commitment and you failed to do that. That's the essence of what makes a security different than all sorts of other relationships between the developers of collectibles and other things from, say, investment contracts. And if the Beanie Babies example weren't easy enough to kind of grasp, you pointed to within the crypto world, I think, very challenging counterexamples that completely undermine the SEC's thesis. Bitcoin, Ethereum. What the SEC has said, Corbin, is that, well, all of the tokens that we've accused in the case against Coinbase and these other exchanges, they're all reflective of a broader ecosystem. This kind of collection of interests whereby if the issuer generally increases the value of the ecosystem that the purchaser of the tokens is now a part of through the token, well, that's good enough to create a binding investment contract securities transaction. Well, if that were true, and I don't think it is true, by the way, for all the reasons I've suggested, why wouldn't Ethereum qualify as an investment contract security? Indeed, why not Bitcoin? Corbin, I can't think of two cryptocurrency projects with a more robust ecosystem and a more robust collection of interests than Ethereum or Bitcoin. And yet, grudgingly, but clearly, even the SEC agrees those are not the subjects of securities transactions. So the logic of this whole thing doesn't make sense. And this is all the more reason, Corbin, why court cases and lawsuits are a terrible way to make good policy. This is why we've been so eager for there to be rulemaking, ultimately legislation by Congress, that reflects upon all these conflicting or even contradictory positions and attempts to synthesize them in a way that market participants can have confidence and understand. Right now, we've just got a bunch of trial lawyers all trying to win individual cases. And as a result, you have utterly conflicting and contradictory positions coming out of these various court cases that make it impossible for investors to have confidence that they know what they're getting into and what the SEC is going to ultimately conclude about what they're getting into a year from now, 5 years from now, or 10 years from now down the road.
There's so many arguments flying around. I hadn't even heard the one about contributing to sort of a vibes-based value environment. I mean, that makes it sound like any country that adopts the US dollar as its reserve currency is like contributing to making the dollar into a security. The SEC has sometimes said the asset itself is the security, and sometimes it's tried to say that there's some contract attached to it. So totally agree with you that the SEC is all over the place and that makes no sense. Let me try and press you on this a little bit.
Please.
Coinbase has reviewed all of these cryptocurrencies and it rejects like 90% of them.
90 plus.
All right, there you go. So aren't you're in effect acknowledging that a lot of these are potentially securities? And if that's the case, you're in a tough spot, right? Because all the SEC really needs to do is catch you on one, right? So is there a gray area that you're worried about where, okay, you're fine with Bitcoin, but this one, this cryptocurrency over here, they somehow slide through and meet the test?
I'm not worried about it at all, Corbin. Here's the thing. First and foremost, while the SEC likes to say, we just need to catch you in one foot fault and your entire operation violates the federal securities laws, that claim is belied by the way the law operates, which is when you make an accusation in a federal district court complaint, the way that the SEC has, and in our case, charged 12 or 13 tokens either as being securities themselves or being the objects of securities transactions, I, at this point, can't tell what the SEC's view is because they've waffled on that basic question over and over again. You have an obligation, regardless, to prove up each and every one of those claims by a preponderance of the evidence with the burden of proof on you, the commission, as the party bringing the lawsuit. So that's number one. Number two, they've relied upon the same generic theory across all of these different token projects, indeed across many of the different cases that they now brought against a wide swath of the industry. And across the entire landscape of cryptocurrency tokens, they have absolutely rested their entire theory of the case, their entire regulation by enforcement campaign on this vibes theory you just described. Literally. Affect the vibes, says the SEC, and implicate the federal securities laws. That's the nut of their theory here that applies whether you're talking about Solana, whether you're talking about any other token that has been accused in these various cases. And so because that is not the law, because no court has ever held that it's simply enough to impact the ecosystem, we think the SEC's case craters not just against Coinbase, but against all these other exchanges. And while it might be tempting to say, well, the SEC is acting in good faith in bringing this ecosystem theory forward as part of these various lawsuits. Here's the other reason, Corbin, to understand why that's just not possible. It's just not true. They didn't even allege this ecosystem theory when they filed the case against us. It's literally a theory they made up. They made up in the middle of briefing on our motion for judgment that we filed several months ago. It was never part of their initial case against XRP and some of the earlier tokens that were charged in other cases. It was never a theory that they articulated in any kind of formal rulemaking. And so, you know, both on substance and in form, it's just obvious they're making this up as they go. And, you know, that is, to come back to your turn of phrase earlier, infuriating. But I ultimately am optimistic. I have to be optimistic that courts over time and with certain, you know, missteps along the way, as always is the case in litigation, will come to view this for what it is, a shifting sand strategy that is aimed more at creating confusion than clarity in the law. And I don't think the courts are going to stand for that.
So to our listeners, Paul wrote the book on this stuff. He authored Coinbase's petition for rulemaking, in which Coinbase actively went to the SEC and said, help us get clarity on this. The SEC did nothing for a very, very long time. Finally, pressed by circumstances, they issued a very brief perfunctory denial of rulemaking. Coinbase is in the Third Circuit, urging the Third Circuit to order the SEC to do a proper rulemaking. So that's, we've talked about the SEC suing Coinbase. Now we're on to Coinbase suing the SEC. And I have to admit, when I was digging into the briefing here, it seemed like an uphill battle, not because you're in the wrong on the merits, but because you can't force agencies to do things. They act in the public interest. They set their priorities. That's the norm. It takes a lot to be a private party and force an agency to do something. That's how I went into this case. I listened to the oral argument, and wow, did you guys seem to do well. And not just because you had Eugene Scalia, although that always helps. Could you tell us about that case, about your thinking, and about, you know, why it seems like my initial impulse is going to end up being wrong? And you guys, you know, you never know from oral argument. I don't want to, but it's looking good.
Well, look, I don't know that your initial impulse was wrong, because the fact of the matter is, ordinarily, agencies do receive a fair amount of deference in setting their own priorities on what rules to consider and ultimately what rules to issue among many different topics on many different issues that come before the SEC. I'll leave the final decision of the Third Circuit to the learned judges of that court. They are currently deliberating on our petition for a writ of mandamus, and I have great confidence in the court. But that's ultimately a decision for the court to make. I'll take a half a step back, though, Corbin, and just give you a bit more of the history that underlied underlies
Yeah,
this
please.
petition. Look, we, as I mentioned, we have been not just open to rules, but begging for rules from the SEC for now several years. And we weren't just sitting around idle, waiting for the SEC to do the right thing. We actually went in and attempted to meet with the SEC over 30 times, 30 plus times, to lay out our ideas for what functional rules could look like, not just for Coinbase, but for crypto as a whole. We laid out our proposals. We laid out counter proposals. And in the back and forth over those 30 plus engagements that we had, eventually there came a time when it was the moment for the SEC to respond, either by telling us where we had it wrong, and that's possible, more than possible. We were eager for the feedback, or to present their own ideas on what registration could look like. And Corbin, after all of that, all of those discussions, all of that time and candidly money and effort that we expended in order to lay out our ideas for what rules can look like, the response from the SEC, well, it was, thank you very much for your time. We're not interested. That was it. That was it. After all that, they had nothing to say about what we had proposed and no ideas of their own. And so, look, no company, and Coinbase is among them, relishes the idea of having to sue their own regulator or potential regulator in order to get clarity. But we felt like we were left with no choice. And that's why we ultimately went into court asking the Third Circuit to compel the SEC to issue or initiate, I should say, rulemaking in this area. And in addition to that, at the very least, to ask the SEC to give us a real explanation, because as you pointed out, when they turned us down, they didn't really say anything. They just said, thank you very much. Have a nice day. Now, fortunately for us, and I think fortunately for the industry, the SEC doesn't get to just set the rules for itself in a vacuum. Congress sets the rules for the SEC and every other agency. And the way that they do it here is through something called the Administrative Procedure Act, which specifies in explicit terms that parties seeking relief or action by an agency are entitled to not just a yes or no, but some meaningful explanation as to the why or what lies behind their reasoning in either granting or denying the request. We got nothing here. And so that was really the basis or the foundation for our request, which was to say, we think rules are a good thing, but even if you disagree, SEC, you got to tell us why, and you have to operate in a manner that is complying with the Administrative Procedure Act. In this case, the SEC did neither, and that's why we felt obligated to go into court, and while we're hopeful that the Third Circuit will see this our way.
Let me turn to another exciting piece of litigation. As I said at the outset, Paul is a busy man. I believe it's actually through a surrogate. It's not Coinbase directly, but there is a FOIA action, Freedom of Information Act, against the Federal Deposit Insurance Corporation company, the FDIC.
Yeah.
So many
Corporation, I
acronyms
believe, but yes,
in the administrative state. You want them to release pause letters that they sent to financial institutions urging them not to work with the crypto industry. The FDIC's actions are part of a larger government campaign to debank crypto firms. As I said at the outset, it's often referred to as Operation Choke Point 2.0. The 1.0 version being when the Obama administration pressured banks to cut ties with politically disfavored actors such as gun stores and payday lenders. I've read up on this a little bit, and partly because it's inside the government, hence the need for the FOIA request. So I don't know if you'll know more than me, but how widespread is Operation Choke Point 2.0, and how coordinated is it? Do we know? And is it ongoing as we speak?
Well, this further litigation involves the FDIC, to be sure, but we actually have yet another case against the SEC that involves another element of this campaign against crypto that I can talk about in a moment, Corbin. But let me focus on the FDIC case, since that's really where you turned our attention to. This suit we brought against the FDIC was really a suit to do nothing more than to understand why is it that the FDIC and perhaps others at the OCC and elsewhere in the government, perhaps the Federal Reserve, were so hell-bent on telling regulated institutions, banks and others, for example, that they were not allowed to do business with people involved in crypto, or at least do it beyond a certain level. And the reason why we were so keen to understand what happened here and why is that, again, like it, hate it, or indifferent to it, crypto is a legal business. And like any legal business, people involved in crypto need a checking account. They need access to basic credit. All of the things that any operation, any business needs in order to run its operations day to day. And yet we were seeing and hearing, and in many cases personally experiencing, clear discrimination on the part of regulated financial institutions. And concerningly to us, it seemed to be at the behest of the regulators, not operating under any law passed by Congress or even published guidance, but just through informal pressure, an effective mandate that said, don't do business with these people, even though they have every legal right to banking services as much as any other any other industry in this country. We thought it was important to shine a light on that. Now, I want to give full credit for bringing attention to this Operation Choke Point 2.0 to many others in crypto who have been fighting for this cause for as long or longer as we have. People like Nick Carter, people like Caitlin Long, who I think in their own ways have done a great service in bringing the public's attention to this real fundamental, I think, violation of due process and just fairness, fundamental fairness that would shock the conscience of any American. And again, regardless of what you thought about crypto, because I would hope that even in these highly polarized times, one thing all Americans could agree on is that if you are a legal business, if you have a legal right to operate, the government shouldn't be able to cut off your oxygen supply through informal pressure in the form of supervisory authority over regulated banking and other financial institutions. That's just not how America is supposed to operate. And so we have gone into court in the FDIC case to try to get documents from inside the FTC under the Freedom of Information Act, FOIA, that would shine a light on what they were thinking, when, and why. And perhaps not surprisingly, the FDIC has resisted our request for those documents that the public, including Coinbase, is entitled to by law. And so we're prepared to fight them for as long as we can.
It just seems so illogical to me. I can think of two reasons to do that if you're the government. And one is maybe you're skittish because of the financial crisis and you don't want a lot of assets in sort of shadow areas that the government doesn't have a good sense of, and that can create risk. And maybe you can speak to that one. But then the other one, like Coinbase, you have know your customer rules. You are as above board as you're going to get in crypto. And maybe it's, a lot of people, crypto has a lot of illegal activity. That's going to happen no matter what. There can be the Coinbase company in America operating with know your customer rules and above board, and the criminal stuff going on abroad, or it can just all be the criminal stuff abroad. You're not getting rid of that by putting the screws to legitimate businesses. I digress. Is it one of those two rationales? Do you know? Do you want to speak to either one?
Yeah. Well, I don't know yet because the FDIC and others have refused to produce the documents. I will observe that at a minimum, if that is the government's view and this current administration's view, why not just say that? Why not just come out and issue public guidance or make public statements that put everybody on notice that this is the view of the current government? For some reason, they've chosen not to do that. And that reason, I think, is rather obvious. They don't have the congressional authority to deny basic financial services to legitimate businesses. Now, as to the relative risk from crypto to the banking system and the traditional financial system, I would just point out, Corbin, that the great financial crisis, which was the seminal moment of financial Armageddon in my professional lifetime, and many who may be listening to this cast, well, that took place in 2008. And the last time I checked, crypto really wasn't much of a thing. in '08 at all. In fact, the original crypto, Bitcoin, the white paper that Satoshi issued, was in many ways a reaction to that. And so to pin the fragility and instability of the financial system entirely or nearly entirely on crypto just ignores history and ignores the reality that there are far greater sources of stress and strain on the system than a bank or another institution providing services to crypto. And so that I think is worth noting. I'll also just point out that to the extent that there are legitimate concerns about illicit activity involving crypto, we share them. It's one of the reasons why Coinbase invests huge sums of money on know your customer and anti-money laundering law compliance. It's one of the reasons why, as I mentioned, we've gone out and gotten these dozens and dozens of registrations and licenses that subject us to the oversight of state and federal regulators and international regulators. And yet, all of that ignores the fact that for all of the hand-wringing and concerns about crypto playing some part in illicit finance in a way that creates stress on, or could create stress on the financial system, the traditional financial system, let's just focus on one element of it, the cash system overseen by the Federal Reserve and the Treasury, has multiples, Corbin, of the illicit activity that takes place involving crypto. And we have third-party independent research from a number of very reputable sources that confirm this. So the logic doesn't hold. The lack of transparency should raise raise red flags. And the fact that the government is unwilling even to provide their own reasoning in the form of the documents that would explain what they what they were thinking when they decided to embark upon this campaign should also raise red flags or ring alarm bells that this isn't about safety and soundness. This isn't about keeping normal Americans or investors safe. This is about a policy preference on the part of an administration that isn't even willing to subject that preference to the debate and scrutiny of our political system. And that should give all Americans great pause, because if it's crypto today, what industry, what part of society is it tomorrow?
I think that's a great lead into the topic of legislation. You're able to say a lot of this with such gusto because Coinbase is above board. So you're not a bank, you're not leveraged, you're not a risk to the financial system, because if you had a run, quote unquote, on Coinbase, you have all the assets. FTX didn't operate so much like that. And to the extent that the government might be afraid of these things, what they're basically afraid of are things that are not a problem if you have legislation in place. Washington Legal Foundation and TechFreedom are both 501c3s. So to be clear, neither of our organizations have any stance on anything to do with this next question. But Paul, what should a legislative resolution look like? We had a bill pass in the House, the FIT 21 Act. You can use that as the basis of building off your answer or go in another direction. Yeah. But I'd love to hear your thoughts.
There's so much that Congress could and should do. Corbin, you mentioned that in the past year, we were fortunate to see a market structure bill pass the House that defined the jurisdiction of the SEC, defined the jurisdiction of other agencies like the Commodity Futures Trading Commission, and provided a real pathway for registration in the way that we've been discussing. What I think was most impressive about that bill making its way through two committees of the House and ultimately the House floor was that it, in an extremely polarized political environment, 71 Democrats joined almost every Republican in voting yes for that bill. That I think suggests that more and more people are starting to understand that the last thing we should be politicizing in this over-politicized environment is something as neutral as technology and code. Now, that bill has not yet made its way through the Senate, but we're hopeful that even in the lame duck session after the election, or perhaps in 2025, we're going to see that happen. And so I'm confident that a market structure bill along the lines of FIT 21 will ultimately be signed by the US president and enacted into law. Now, there are other elements of legislation, other pieces of legislation we think are also important. A bill on stable coins has also been introduced in the House, and we think is deserving of a vote, ultimately passage by the Senate and signature by the president. And that legislation would provide basic standards for stablecoin issuers in terms of what types of reserves they have to have in order to back up their stable coins, how much they have to disclose about those reserves and other elements of their operation to purchasers, and what type of oversight they should be subject to on a going forward basis. So we think market structure makes tons of sense. We think a stablecoin bill makes tons of sense. And there may be other topics as well that are worth legislating on in the coming months and into the next year. The point, though, Corbin, is whether it's one particular bill or a comprehensive piece of legislation, it's past time for the United States to act here, because even as the U.S. seems to be frittering away its extraordinary lead in technology, in people, in creativity, the rest of the world is not waiting for us. Europe has passed sensible, even if tough, legislation. Singapore, other countries all over the world are following suit. And so, again, whether you love crypto, you hate crypto, or you're indifferent, if you love America, if you want to see America continue to play a dominant role in the global financial system, we should have rules. And I think more and more Democrats, Republicans, and others are coming to understand that.
You've mentioned cash, you've mentioned stable coins. I'm going to tie that together and ask you about central bank digital currencies. For listeners who are maybe unfamiliar, this is the idea that we could basically get rid of cash and do everything digitally. Currently, that's overstating it, because I don't think anybody is out there hollering for a retail digital currency. This would mainly be something for banks to use. What are your thoughts on that? Is that something that Coinbase is pro or anti or neutral, or what?
Well, I think candidly, we're skeptical that a CBDC could make sense or would make good sense anytime soon. The fact of the matter is that a programmable currency issued by the United States would combine all of the efficiency of the post office with the charm and customer service of the IRS, right? So,
and the potential surveillance of the NSA,
and throw in the surveillance dragnet that many of us fear has come in the wake of the Patriot Act and other legislation by Congress over the years. And so it I think is frankly the last thing that we need to focus on right now in terms of sensible cryptocurrency policy. Corbin, we're lucky. We're so blessed that by and large, the private sector has supported the development of this incredible technology and made it available to tens and tens of millions of Americans in the face of extraordinary hostility for the government. Imagine what kind of adoption and use cases we would see emerge if the US government, at the very least, just got out of the way, let alone supported this technology. So I think that the path towards a brighter, more robust financial system and future that is based at least in part on cryptocurrencies largely lies outside of any central bank digital currency and much more with private initiatives that are subject to government oversight, rules, standards, and enforcement where necessary. But I don't think a CBDC will get us there. And the fact that other countries around the world that have made more of an effort in this area have struggled and in some cases failed, I think tells you that these are technologies that are best developed by the private sector.
Amen. To the extent that's going to happen, I'd certainly rather see it be a Coinbase stablecoin than something sponsored by the government. Paul, this has been fantastic. Surprise last question. HBO just released a documentary claiming to unmask Satoshi Nakamoto. The thing that is most interesting to me about this, there are many interesting aspects. He, she, them, if they're even still alive, sitting on $68 billion in unclaimed Bitcoin. What is up with that?
Well, it is one of the great mysteries of our time. And I think it is, in terms of dollars, certainly one of the most valuable mysteries of all time. I don't have any announcement on this cast today in terms of my own role in creating the myth of Satoshi Nakamoto, but I can say that the fact that we are all still talking about Satoshi nearly 15 years after the original white paper suggests that this was an innovation whose story will be told for many generations yet to come, even if we'll never quite know who Satoshi was.
Paul, this has been a privilege and an honor and loads of fun.
Likewise.
I am Corbin Barthold. For purposes of the Tech Policy Podcast, we will wrap up right here. If you enjoy conversations like this one on the podcast, please do give us a 5-star rating and a good review and all of that great stuff. And while you go do that, I will wrap up here with WLF and get started on the next one. Thank you all.
Corbin, Paul,
Glenn,
thanks so much for joining us here today.
Thanks.
I think everyone learned a whole heck of a lot. I know I did, and this seemed like a really quintessential sort of Tech in the Courts podcast and webinar, just because of the many things that were discussed here today. For those of you who may have joined us late, or if you know someone who might be interested in watching this will be available on WLF's YouTube site as an on-demand video, and also Corbin will have it out, as he said, as a Tech Policy Podcast very soon. And I expect we'll get a good number of viewers and listeners that way as well. Again, Corbin, Paul, thank you so much for doing this with us today.
Thank you, Glenn. Thank you, Corbin.
Thank you, Paul. Thank you.
Have a great day, guys.